looks okay. Just needs to log in, I think. The fact that's come on, yeah. You know, no, I'm like already. Yeah. Authorised.
Application in the matter of UCP and Nectrus Ltd.
Good morning, my lords. I appear on behalf of the applicant, together with Mr. Legg and Mr. Blakeney. Mr. Davis QC appears with Mr. Wardle for the respondent, UCP. And this is my renewed application on this 5130. Can I begin, my lord, to apologise for the issue about the bundles? Plainly, insets would have been a far more sensible
Sorry,
way.
it was a trivial matter which I didn't even bother my lords. It did seem a terrible waste of paper, but enough said about it.
My lord, please. My lord, the way I'd like
Just to be clear, Mr. McGrath, I've only got two electronic bundles, something called an application bundle and an authorities bundle.
That's correct. Lord. The issue was just simply a replication of an old bundle with the new inserts. But your lordships should all have two bundles, one being the application bundle and one being the authorities bundle, whether a soft copy or...
What happened, just so nobody, is that you wanted at a late stage to put in two inserts instead of, and we got all the bundles all over again, which I was annoyed about because I'd already marked up the first one. But these things happen. So,
my lord,
I'm paper free, Mr. McGrath, so I didn't have that problem.
My lord, I'm hybrid. So I'm bound to get into trouble at some stage during the course of these submissions. Well, the structure of my submissions, there are three key stages to my submissions. Stage one relates to the determination of what I'll call the withdrawal order, as I described in my note, back in July 2020. And we say in a nutshell there that the judge reached an erroneous decision via a fundamentally flawed process, which in the events denied Nectrus the full opportunity to present its case before that termination. And obviously have to make good those.
Did he ever apply the test under 5218? No.
Pardon, my lord?
He never applied the appropriate test for withdrawing a permission to appeal.
No, my lord, he never applied the...
Because the appropriate test is actually provided for in the rules, 5218. Nobody's ever mentioned it.
No, my lord.
No. Why would you?
No, my lord. And
procedurally, it's critical. Yeah.
My lord. And stage two are the events in the immediate aftermath of the withdrawal order. Now, these events, namely two matters, the refusal to issue the 3.35 application and the what we now understand to be the imposition of the time period on the 5230 application. Those two matters are not critical to this application, but we do say that they are important events which inform the fair-minded observer as to the attitude or the appearance of the attitude of the judge to a challenge to his original decision.
So refusal to issue 3.3 and
the imposition of the time limit on the CPR 5230 application.
If that is what his direction meant,
if
which
that's
you
what
didn't think it did mean at the time.
No, and I'll address
you were only given 24 hours to do it.
My lord, yes.
Is that's the point, though?
Yes, it's not a great point. If they're right on construction, then we were imposed with a 24-hour period to get our acting gear for a 5230 application, which is plainly, we say, insufficient and creates all the wrong incentives, some of which no doubt we may discuss today. And then the third stage is the renewed application, and the key, the first application on the 5230, and the key point here is whether or not the judge should have recused himself. The handling of...
Sorry, you said the renewed application?
We're
talking about the first application.
The first application,
yeah.
Whether the judge should have recused himself from hearing the 5230 application in January 2021. Now, there's also an issue as to the handling of that, the interruptions, etc., which you've seen in the supplemental skeleton. But if I don't get home before your lordships on the refusal to recuse issue, then the handling will be viewed in a different light.
But the problem is you never asked him to recuse himself at the hearing.
We didn't, my lord, no. Yeah. We did ask 3 times for him to recuse himself.
Whether it's 1 time or 3 times or 2 times doesn't matter. You asked and said you wanted another judge, and the office wrote back saying you can't have another judge. That was the end of it. Well, but you don't even, we don't even think, looking at the papers, that the judge was actually specifically asked. They just wrote their normal stock response.
Well, it was on the skeleton as well, my lord.
But you might, sorry, friend, I want to make sure I've got this right. In fact, the stock response didn't say you can't have another judge. It said it would go in the first instance to Lord Justice Flaux. And he is well placed to decide whether or not he wants to recuse himself. You then wrote back along the lines of we'll be content with whatever is with the decision of whatever judge deals with it. Looked pretty like accepting that it might be appropriate for Lord Justice Flaux to deal with it. Then you're told it is Lord Justice Flaux, and you don't object at that point.
Well,
or rather, you're told that Lord Justice Flaux hasn't recused himself because he's going to conduct a hearing.
Yeah, my lord, when we deal with the right to recuse, I have to accept 2 points. One, your lordship has just referred to, which was the response to the indication that you weren't getting a recusal, which I'll show your lordships, but was, we say, a polite response, but can be understood by others as suggesting that we weren't pursuing, or might be understood as we weren't pursuing the application. But it came against making our position very clear. We say that we did not consider the judge to be an appropriate judge to hear the case, given the nature of the allegations. And the second point that we said against me is that you didn't pursue a formal application in that respect. And we, again, I must accept that that's an accurate portrayal of the events, but in circumstances where it was considered that the issue had been raised squarely and no chink in the door of another judge coming in was offered, that it was decided to proceed as was. But that process, it had been very clearly made on our side that we weren't, or Nectrus was not content with the judge that was hearing it. And in any event, and this is some of the points that I'd be saying anyway, the decision of the judge to hear it is itself a matter to be considered in the light of the submissions I will make as to the suitability and otherwise of the same judge hearing this particular 52.
Did the judge decide to hear it? That's the question I'm asking.
Well, he
did the judge just simply have it listed before him and hear it? Because that's what seems to have happened, is that there was no application made. Nobody stood up, standing where you're standing, and said, my lord, the first application is that you shouldn't hear this. And because otherwise he would have dealt with that in his judgment. There's no mention of recusal in his judgment at all.
No, my lord, I can't challenge your lordship's...
So when did he decide to hear it? As far as I know, it was listed in front of him in the usual way. You see, the thing that bothers us, Mr. McGrath, is there are 2 stages to an application under 5230. And the judge in this application never distinguished between the 2. When you put in an application under 5230 to reopen a final determination of any appeal, you do so, you have to ask for permission. Permission is needed to make an application under this rule to reopen a final determination of an appeal. That's sub-rule 4. And there is no right to an oral hearing of an application for permission. So what happened here was that the court somehow, don't know who, directed an oral hearing. Probably somebody rang the judge and said, what do you think? He said, oh, let's have an oral hearing. And it wasn't clear whether that was subsequent to permission being given to reopen, or whether he was dealing with the permission to reopen. Because when he deals with it at the end of his judgment, he says this application is dismissed. Which doesn't tell you the answer to that question.
No, my lord.
So, submissions, please.
My lord, can I just deal with the issue? Your lordship meant as to when did he decide, or did he decide? But my Lord Justice Underhill has pointed out that the response from the court was that we put the application back before the judge, and it's for the judge to make the decision whether they consider it appropriate to hear that case. So that's the practice that we're told is done.
Well, to deal with the case, not necessarily to hear it.
To deal with the case.
Well, yeah,
So
to
we
consider how the application for permission, well, to consider the application for permission, and as part of that, to consider whether they should hear it. I mean, I'm assuming what you're assuming, he's probably right, is that before it was ordered into, it was listed for a hearing, Lord Justice Flaux would have had the papers, which would include both the appellant's notice and the skeleton argument, which asks for a recusal, and will have said to the office, I think there should be an oral hearing, because there can't be one unless the judge so directs. Yes. That's 5235. So as I understand it, your point is that he must be taken to have been aware of the application for recusal, and decided, at least at that stage, not to recuse himself. Have I understood how you put it correctly? He doesn't say so, but it's implicit in what he goes on to do, namely have it listed in front of himself.
My Lord, yes. I mean,
though he may well, just to finish off this line of thought, it sort of cuts both ways, he may well have thought, well, if they don't like it, they can object.
Well,
and then then I'll have to deal with it either on paper or have
there's
a
an
separate
alternative.
hearing.
There's an alternative to this, which is the judge was never asked.
Well,
because it is possible, these things do happen, that you having, as you said, on one analysis by a polite response withdrawn the application or not progressed it, the office thought, well, there's no need to bother the judge, they're not pursuing that, I'm just going to list it.
But my Lord, with respect, at some point, the judge will have read the papers.
Yeah, 10th of January.
In which it was clear to him what was being said about his suitability to hear this case, and he's content to continue.
Yeah.
On that basis.
But I mean, it's a big thing to say that he should have recused himself as at the 10th of January, when you didn't ask on the 10th of January.
Well, we hadn't withdrawn the skeleton. So if he only read the skeleton.
I see. The skeleton did say, yeah.
The skeleton was the
and indeed
box,
the original application.
Yes, the box number 8.
Yeah.
And that refers back to the skeleton.
But that's why I'm puzzled, you see, because...
But look, can I make this point?
Yeah.
That we are dealing here with whether something has gone seriously wrong as a matter of procedural justice. And we can argue whether we were right or wrong not to make a formal application backing up our requests about recusal. But one thing's very clear. We asked for this judge not to hear this case. Rightly or wrongly, we made that request. We explained why we didn't want this judge to hear this case. We were told that the judge would be sent papers and the judge will make up his own mind. That's what we do in the office. No criticism there intended of the office. That's the procedure that we were told. And then the judge sets out a set of directions about hearing the case before him. And he does that on the 3rd of November 2020.
What's the page number of those?
That is 180 for your lordship, tab 3 of bundle 1, 180. So,
Sorry.
tab 3,
Yes.
page 180 using the red in the middle.
Yes.
That's Lord Justice Flaux has directed that the application for permission to be opened should be listed. So that's permission he was dealing with.
Yes.
So on that analysis, he refused permission to be opened. So he never gave permission to reopen.
But what it does show,
This was a direction under Rule 5. Under.
but what he didn't, so what this tells us is that he's been involved in the process of the listing and is giving directions here for the appropriate, back in early November for the hearing in January.
Okay, that's correct. That's helpful.
So, well, I mean, I don't in any way seek to challenge the obvious omissions, that there was no formal application to recuse and the point wasn't repeated orally at the start. I simply make the point that the issue about the suitability of the judge had been placed squarely before the court, and the court system had said that the judge would hear it. And the
So
judge,
how do you deal with, I mean, I understand your submission on this. How do you deal with Rule 7? There is no right of appeal or review from the decision of the judge on the application for permission, which is final.
yes, but my lord, all that tells us is it's a final determination. But the 5230 itself is a procedure, an exceptional procedure, which has been created in order for us to deal with situations in which an erroneous decision has occurred through a clearly, critically undermined process.
But your stages 1 and 2 of your 3 stages are all matters that were canvassed at the first 5230 hearing. And so, as my Lord the Master of the Rolls says, aren't they squarely within 5230 sub-rule 7? And you are asking us to at least review what Lord Justice Flaux decided in relation to those matters. I'm leaving aside the recusal point for a moment. You're asking us to review those exact points at a second hearing.
My lord, yes. Yes, I am asking.
Isn't that contrary to the rule?
Well, no, because 5230, we say, is the mechanism by which one would challenge such an order insofar as you can get within the high criteria of 52.3, the real injustice and the exceptional circumstances test and no alternative remedy. As your lordship has seen, that
so sub-rule 7, you can outflank sub-rule 7 and, to use Mr. Davis's words, recycle the old arguments on a second application.
But that's to recycle, my lord, is to look at it the wrong way round. They were never cycled properly the first time, if I'm right about recusal.
Well, I'm leaving aside recusal. That's a separate point. I see the point about recusal.
Because the test, I mean, if you look at it this way, my lords, we had a PTA hearing that went, we say, rightly or wrongly, went wrong. And then the rules provide for that
decision.
PTA decisions that went wrong. And we, although it's the process as well as the decision, my lord, that we obviously...
yes, I'm just picking up on hearing, because that's confusing.
I do apologise. That went wrong. And the CPR provides an exceptional remedy to deal with that situation. Except we say we never got the benefit of that remedy that is permitted to us under the CPR.
Because Lord Justice Flaux did not recuse himself.
Yes.
But yes. But the real question then is, let us assume, maybe not to say like that he should have recused himself, and that therefore there was a serious procedural flaw. and you are, for that reason, effectively not bound by the decision he made on that occasion. The question then is, if there is a second hearing or a second application, which is what's in front of us now, you can rely again on points that were dealt with first time round. You say you can because of that flaw.
Well, yes, because, my lord, the thrust and driving force of this application is not some esoteric question as to whether the judge should have heard a 5230 application. It is the erroneous decision at the PTA and the process by which that was reached. That is the real injustice which drives this case. And one can't ignore that, put that in the box and put it in the corner and just look at the question of the recusal separately. Because whether the judge should have recused himself is determined by reference to and inextricably tied up with those events that took place for the original withdrawal order back in July, plus the events immediately thereafter, which we say are important building blocks to the argument. One can't, we are again, and I sometimes one hesitates to refer to language like natural justice and procedural justice in a courtroom. People usually think that you're sort of at the end of your tether or whatever in an argument. But in this courtroom, for this application, it is important that a holistic all-round approach is taken. Where we fairly and properly dealt with at that initial withdrawal order, answer we say plainly no, both as a matter of law and as a matter of procedure. Were we then afforded a proper remedy under the CPR? The answer we say to that is no. And that you need to look at all of that in order to decide whether today, on this application, we succeed. And
but you have to have grounds for your application. So I understand now that your first ground is that you didn't get a proper 5230 hearing because he was he should have recused himself because he was being asked to evaluate the procedure that he himself was wedded to on the second PTA, what we might call the second PTA application. So that's the first ground. The second ground, but that's really the only ground, because you say he should have recused himself. And then what weight do you place on Primeo? Because the problem with Primeo is that he actually founded himself on a fairly reasonable argument that Primeo in the Cayman Islands Court of Appeal had reached the clear view that you were wrong. And he said, I therefore think it's unarguable. And you say, well, it plainly wasn't unarguable because of Primeo in the Privy Council. But that's only a small criticism if he was going to decide it shouldn't be reopened because it was covered by Primeo in the Cayman Islands, with which he agreed, on the basis of Marex.
The problem your lordship's got in looking at the hearing itself, the January hearing, is that one's dealing with a situation of apparent bias recusal. In that situation, the fact that the judge might have reached the same conclusion had other factors not been in play is not as telling as it would be in a situation where I said...
So do you say he's apparently biased because he'd already decided in the second permission application that the argument on Marex was wrong?
Yes, but also for the reasons of the fair-minded observer looking at the events in the immediate aftermath. Because importantly, my lord, without going down a procedural warren hole of CPR 3.35 and the rights or wrongs of that application, your lordships will be aware that when we were informed of the order on the Friday, by the next Tuesday, we're asking for an extension of time for the CPR 3.35 application. Now, the judge said, when we then listed that application, or tried to list that, issue it, the judge refused to allow us to issue it. Now, however one might view the merits of that application, we were entitled to have it issued and then dealt with as to why it was wrong. Because if we were right, that sends us down to a simple rehearing.
But it seems you were both wrong. I mean, so far as I'm concerned, and I'm speaking only for myself here, but I think one should look at the CPR before you make applications. The judge had on a proper analysis of the first permission to appeal order, he had granted you permission to appeal. Full stop. It says at the beginning, you are granted permission to appeal on ground 2. Right? And then he says all sorts of conditionality, which I don't really get, but anyway, he did. And the only way in which you can set aside a permission to appeal application is under Rule 52.18, and 52.18 is very specific, and it says the grounds, and the grounds are, and I emphasize I'm only speaking for myself here, the court will only exercise its powers under 1 to set aside permission to appeal in whole or in part where there is a compelling reason to do so. So the judge ought, on the occasion of considering the second permission to appeal application, if he was dealing with it properly, have decided whether there was a compelling reason for doing so, which he didn't. He didn't even apply the rule, wasn't asked to. But whether that matters or not, I don't know, but I just make the point because I'm a bit of a CPR geek.
Well, my lord, but then can I just add to that point that that only really shows that the manner in which that process was conducted was unfortunate, we say, because there was no clear procedure.
It wasn't his fault. I mean, he wasn't told.
No, he wasn't told, but then he never
It
set
might
out
be
anything.
said, I don't wish to be unfair, but it might be said to be slightly his fault because he makes the order at a time which, speaking for myself like my lord, I find difficult to analyse. There's no such thing as a contingent grant. It can only either be conditional, and this doesn't look like a conditional grant under 52.6, it's not so expressed. So it must be an absolute grant. And when he said it was contingent, what he must have meant was that he would have another look at it without identifying what power he had to have another look at it.
He said that. He said, I want to have another look at it, which is fine. He's allowed to have another look.
The point I was making is that in a sense, the judge set this problem up by saying what he was going to do without identifying the power under which he was going to do it.
Or the process by which he was going to do it.
Yes.
But I mean, I think, speaking again for myself, I think the letters, and the 2 letters he received, which he acted upon, I mean, again, without being silly about it, it was the end of term. Judges are known to quite like getting things off their desk at the end of term, and that's not wicked, it's good for the parties. He looked at those letters, they weren't 100% clear as to what the position was. You can argue as you have, we should have been given the opportunity to have more time, and he can say, if he was asked, well, I thought they'd said all they wanted to say. I mean, both positions are legitimate, they're not wicked, they're not done deliberately to do anybody down. The only thing that's wrong, really, is not applying the CPR test and analysing what he had done the first time and what he was doing this time. But then you come along and say, well, I've been done down, and then you say, okay, but then afterwards he demonstrated he was cross with us, refused us permission to issue a 3.3 application, which, whether it was right or wrong, was not his place to do. You don't need permission to issue a 3.3, I don't think, do you?
No.
So you say I should have been allowed to do that. Then he put me on a strict timetable for the 52.30, and you say that was unfair too. And then you say, okay, and then when it came to recusal, he ignored us, effectively.
And of course, part of the decision on 3.3.2, my lord, is what he said it wasn't, was it didn't fall within 3.34 of the White Book, which is that the court may make an order of its own initiative without hearing the parties or giving them an opportunity to make representations. Now, the parties were obviously not heard, but he considered and must have considered as part of his determination not even to allow a listing, an issuing of this application, that the parties had been afforded a proper opportunity to be heard. Because they weren't physically heard in a hearing, so they must have had an opportunity to make representations, which he refers to the letters as being those representations. So importantly, what I say is that he formed, if you're asking, was this judge to a fair-minded observer closing his mind to the question of how one can construe or take or understand the letters and the exchanges? The answer is plainly yes, because he's refused to even issue the application under 3.34. And that's without my even going on to the argument that he never considered the alternative grounds that Mr. Ammon sets out, that where you choose to make a decision without a hearing, it's deemed to be one of your own initiative and therefore fall within the test. He just simply said, I didn't do this of my own initiative. But he didn't consider that. Now, I'm not here to say whether or not that argument would have won or not, but it was never tested. We were never allowed.
It's your former argument that's the more important from the
Yes.
point of view of apparent bias, isn't it? As
Yes.
I understand it, you're saying, I hadn't fully appreciated this, that the denial of the issuing of the 3.3 involved him taking a position on a definitive position, which actually had procedural consequences, on the very point which was then relied on in the 5230.
Yes, which was at the heart of the 5230, which is the letter shouldn't have been read. And my lord, obviously no one is suggesting that the learned judge did anything deliberate here. And I fully take on board, as my lord the Master of Rolls points out, the timing of this towards the end of the legal year and the sense in dealing with matters quickly. But that order that I showed you earlier on at 180 is precisely all I would be asking that this judge should have done in order to sort out the process. The tab 3, page 180, a couple of lines, your lordships have seen it, as to putting in arguments, closing off the dates for further submissions, etc. It doesn't take a great deal of work to do that. But it is a central tenet of natural justice that one knows the procedure by which one's issue is to be determined. And that is crucial here, because it's all very well and good to blame Nectrus as to the clarity of its letter. But why is that even an issue here? It's an issue here because there is uncertainty as to what that letter constitutes. Well, where's that uncertainty derived from? It derives from the absence of a clear procedure and stepping stone procedure in which that letter would fit in. Even if we had written a letter and then the procedure was put in place, if everybody knew how the judge perceived the letters and was thinking, then people would know how to act accordingly. But no one did except the judge, and he didn't communicate it. And I thought this is just basic procedural justice.
Can you just say that again? He didn't communicate what?
He did, well, he formed a view clearly as to what he understood Nectrus' letter to be, against a background where there was no timetable he'd set out that stipulated and would have made it clear what such a letter was meant to be. So he formed a view and then made a decision based on that view.
Yeah.
And seeks to now justify it by reference to close textual interpretation of the letter and how it could have been clearer. I'm positing it the other way round, that as ultimate case manager, he had responsibility to set down the clear timetable for the determination of that issue, as the example in 3, page 180. He didn't do that. Had he done that, there would be a clear framework against which to assess the steps that each party took. We wouldn't be in the realm of what does this letter really mean? Have they got more things to say? Can I close the book on it? Because the timetable would have said, set out your case here, reply here, and then whether or not there would be a further point, what have you, is after. But everyone would know, under the normal PTA process, you have a full skeleton of the party whose interests are really at stake, the appellant, and you have a short 3-pager from the other side. And one can see, when one looks at the letters, one can see that that was precisely what my friend's clients were seeking in the event that the judge was not in favour of dismissing the PTA decision based on their letter alone. So we say that the criticism of the clarity of the letter, and we do say, and I'll put my hands up, it could have been clearer, but that's not the fault that's relevant here. The fact that its clarity is only an issue because of the absence of the clarity of a timetable against which it would be assessed. And the responsibility to that vests with the court. He didn't have the benefit of a set CPR procedure, so he had to put one down. And that all that required was submissions on day X, 2 weeks later, or 2 days later, however short, to get it in.
Well, if we can summarise, Mr. McGrath,
Yep.
You say, I think, there are three things that lead to the implication of apparent bias to the independent observer, whatever the Porter-McGill test is. The first is that he refused to have submissions on the second PTA before deciding it, and never gave you any explanation as to why he'd done that, and followed a process which was unfair and was then the subject of attack, but it was the process that he had followed, so it was an attack on him, which is why it's an apparent bias question.
Yes.
The second point is that he showed further bias by denying you the right to issue a 3-3 application, which again became the subject of the attack, which was an attack on him, and therefore, again, subject to apparent bias. And the third, and perhaps more difficult one for you, but anyway you say, I think, is that he'd already decided the Marex Primero point against you on the second PTA, and therefore asking him to change his mind on that was a big issue, and something particularly, perhaps you might say, when he was so steeped in Marex by having decided the Marex decision in the Court of Appeal.
Yes, and can I say this? I mean, obviously, the view on Marex, he also commented in the judgment that, as regards the polite language in Nectrus's letter, if you would like further submissions, he commented on that and said, well, you know, if I can read it and make my own decision, why do I need your help? Well, I mean, that's not an answer. You may not need the help, but you're going to get it, and you have to listen to it. You can cut me off when you think I'm going off on one, but nevertheless, you have to give me a chance to at least go off on one. It's not for the judge to form his own view without the benefit. Not on a critical issue that's then going to affect my client, because of course, if he decided the other way, on his understanding of UCP's letter, he would have had to give them a chance to put in further submissions, because he accepts, he concedes, had I understood the letter to be a request, then I would have been duty bound, otherwise be in breach of natural justice, to comply with that request. And I say, I mean, I think I used the expression, it's just natural justice is not a la carte. It's not something that one chooses a selection, and that if you don't choose it, it's not in your favour. It is the reason he'd be in breach is not that he failed to respond to the request, but that he'd failed to comply with natural justice. That's why he'd be in breach. The breach is one of natural justice, not of a request. But let's get, with respect, some common sense here. A big decision comes down. A few days later, there's a short letter by my client. Then there's a letter a few days later by UCP. We have taken diametrically opposed views. Diametrically opposed. They say the letter, that Marex is so obviously in their favour, you can decide it on the letter. You don't need to. But if you're not sure, give us time for some submissions. We say you can decide. The only thing we invited the judge to do was to remove the contingency. We never invited him to do anything else. But we also say, however, in the alternative, if you're not minded to do that, we can put in further submissions. They said it clearer. We said, if you like...
They actually didn't say it clearer. They said, we asked the converse, I think. Those were the words.
The converse of what we were asking, which was...
You were asking, as you say, to remove the condition, whereas you should have been... They should have been asking, not the converse of removing the condition, but they should have been applying under 5218.
Yeah. Well, my lord, yes. I mean, frankly, your lordship, as your 5218 point, has simply identified that the failing in the process, in setting out a clear process where parties would have been able to set it out. I don't know what would have happened, my lord, and I'm not going to say suddenly the light bulbs would have come on and everyone would have understood 5218.
No, I mean, I think the light bulbs were never going to come on because the judge had a clear view of Marex. He understood all the issues. He'd been into it uphill and down dale. He no doubt read with annoyance the Supreme Court's decision overturning him because he's human. And he probably just went with it initially on the 28th of June, whatever it was, 26th of July, and said, well, I think, okay, I'm wrong, so there we are. And then he looked at it in great detail and gave all the reasons in January. But, you know, the fact that he did all that is not normally regarded as bias.
No, but it's not. But neither is a good judgment a wipe clean of the slate of a hearing that shouldn't have been heard by that judge.
That's where all these points ultimately get you, isn't it?
My lord, if I don't get home on
the 3
refusal.
points that my lord has put to you lead, you say, to the conclusion that Lord Justice Flaux should not have heard the 5230 application.
Absolutely, my lord.
And I mean, unless you can make that good, you are then recycling arguments that were considered first time round.
Absolutely.
And the 5218 point is a sort of Barclays Bank and Guy point you could have taken but didn't.
No, and as you've seen, the way the submissions are made here, although my lord Master Groves has mentioned it, they're not in my submissions in the way that I've put the case. But I say I don't need 5218 because the process was flawed for the reasons we've said.
Yeah, was the flaws in the process leading to the conclusion that Lord Justice Flaux should not, or the alleged flaws in the process, should I say, which included criticism of the procedure which Lord Justice Flaux himself had adopted, plus the very trenchant terms in which he withdrew the permission, leads to the conclusion, you say, that he should not have heard the 5230 application.
My lord, yes. I mean, if we looked at, say, as has happened in many of the other cases, and this submission isn't, my lord, and I should make this quite clear, it isn't that the same judge could never hear a 5230 application. It could be a situation in which the issues that are relied upon don't involve the judge having gone wrong himself or responsible for something having gone wrong, but that he can properly assess it in circumstances where, to use that awful expression, he doesn't have any skin in the game.
Yeah,
it wasn't his.
Here you're making, as it were, personal criticisms of the judge's conduct.
We're criticising as regards the PTA decision and that process. We say that natural justice was not done because he didn't set out a process clearly and then reached a decision without giving us a full opportunity to respond to any points raised by UCP in their letter. The criticisms of an absence of an express request, frankly, only serve to show why it's inappropriate for the same judge to deal with this, because he hung on to that with respect like a dog to a bone at the January hearing as the reason why he was right.
What did he hold on to?
The fact that if you wanted more time, you could have asked for it. Your lordship will have seen the extracts in the supplement skeleton. I mean, he couldn't wait to get on to that point. He was quiet for a few paragraphs, and then bang, he went in on that point, and that was the point he returned to time and time again. And I've addressed your lordships briefly on the point about request. Request is not the basis for triggering natural justice.
Well, what you say, and maybe there are lessons to be learned here, in the Court of Appeal, we deal with a lot of applications that come in by letter, by in the run-up to an appeal, where a party asks for something fairly uncontroversial, like permission to put in 5 million pages by way of a supplemental bundle, which we normally refuse. And the point is that we don't always say, and you say we should, don't make that order until you've heard the other side and got the reply from the applicant. Now, where does it stop? I mean, he thought, looking at it from his point of view, and I've seen this happen so often that I can empathise, he thought, rightly or wrongly, he had all he needed to decide the point. He said, a simple point of law, I'm ideally suited to decide it because I did Marex and I've now read the Supreme Court, so I know the point and I'm going to decide it. Now you say there is no natural justice in every case unless you call for, set down a proper procedure of submissions. You can do it on paper, but you have to let everybody say what they want to say.
We'll save that, my Lord. Obviously, some common sense has to come into play here, and natural justice is considered in the round. In your Lordship's example, it's, can I put in some extra documents? Now, you're making that decision. As to
what I normally say when I make such orders is you can put in the extra documents, and the other side, if they've got anything to say about it, can apply to set aside that order.
Well, then that gives them an opportunity to have their say. I mean, what could have happened here? Because I don't want your Lordship to go away, or your Lordship to go away thinking, well, McGrath is saying every time anything comes in by way of a request, that some tremendous procedure has to be laid down. Let's take the facts of this case. What could have happened is that we put our letter in. The Court of Appeal Office, in fact, did, after we put in our two-page letter, respond to UCP and say, is this agreed? And they rightly said, no, not agreed. Now, that is entirely appropriate because they're affording UCP an opportunity. So UCP then come back with their letter. Now, at that point, the judge hasn't set down any fancy procedure. The parties have sort of gone off on one. They put in something. What they put in, and whether that's their last word, isn't known by anybody at that stage. All that needs to be said is, to the party who is the appellant and therefore would always be given, the proposed appellant, would always be given the chance to put the most in, because if you've got to say no to them, then it's obviously right that they have the best opportunity. All it would need at that point is for the judge to say, do you have anything further you wish to say? If so, put it in writing within 2 days or something. And then I wouldn't be able to say to you, oh, but when we wrote the original letter, there was uncertainty as to how one characterises that letter. The judge is clearly characterising that as part of the process. He's told us that, and he's given us an opportunity to respond. It's as simple as that. So I'm not suggesting that there's some tremendous change in procedure, but just naturally the thought process which naturally occurs to judges.
I mean, obviously the other side don't agree with your characterisation, but assume you're right on the 3 points I put to you, and at the very best, or the very worst for you, the judge ought to have considered recusing himself and ought to have recused himself. You say that's fatal to the application, entitles you to make another 5230.
My Lord, yes, and concerns about renewed applications and floodgates simply don't arise, because your Lordships here will decide whether I'm right or wrong on the point of recusal, which is key to that question, and will therefore lay down guidance. And in the limited number of 5230s that I've seen, I know that they're growing, sometimes it's the same judge because there's been no issue, and what's in issue is fairly banal. I know my Lord Justice Lewison, I think, did one recently, and then there are those that fall into the category that we say ours do.
Well, Mariana is another one.
Mariana, exactly.
It was hardly inconsequential.
And I think the point's sometimes lost, because there's quite a few cases that are cited about a judge refusing permission to appeal on paper then sitting on the appeal, and that's not a problem under the old procedure. But as the cases like Stubbs and Queen make clear, that judge is making a decision on paper, knowing that it is capable of being reviewed, that it can be subject of all submissions under that procedure, and that when he comes to sit on the panel in the substantive appeal, he can do so because he's not reviewing how did the original paper application go on. He's reviewing the question of the overall merits and didn't form any final conclusion. But under the procedure that we're now dealing with, the decision to withdraw or refuse permission to appeal is a final decision. And so it starts off at a higher level of concern to a fair-minded observer about the closed mind. It is already further along the lines than those old cases, and there's a danger that parties are reading those old cases and applying it to a new procedure. But it isn't the same. And all the reasons for allowing, or Justice Laws or what have you in Sengupta to sit in the appeal are the very reasons why you wouldn't, or we say you shouldn't have allowed, or it shouldn't have happened that Lord, the judge in this case sat in this, because he did make a firm conclusion. He made a final determination.
Well, by definition, in one sense, that will always be the case on a 5230.
Yes.
So you're really having to distinguish between what the nature, the decision will always be a final determination. Yes. The distinction must surely be the nature of the issue that is relied on as justifying reopening.
Yes.
What would your position be on what sometimes described as the paradigm of the judge who by accident wasn't given the final papers, so didn't perhaps have the one-side submissions? Would it be said, well, this was a final decision and they reached a concluded view, and now it will be difficult for them to reach a different view, now they see what the other side say?
No, I don't speak in those absolute terms.
No.
Because that awful expression about skin in the game does mean something. It means that the judge can properly, and we rightly expect our judges to be open-minded in that scenario, to say, well, now I've seen all the evidence. It happens all the time, for example, on freezing orders, ex parte, and then the same judge looks at it again and says, well, if I'd known that, I'd have had a different view of this. There's no suggestion that there's any criticism of the judge first time round, because new information's come up. And then he looks at the new information and can plainly make a determination based on that. But so I'm not saying that, but what I do make the point that the decision is higher up the chain of closed mind factor than the old paper permission to appeal.
It sounds though as though you're saying that 5230 ought to be much more widely applied than has hitherto been the case, because the original PTA decision is final. Is that what you're saying?
Well, I'm not advocating, and don't need to advocate here, that 5230 should be more widely available. But I do say that there's a danger that it's the initial decision shouldn't be confused for the provisional and interlocutory decision that we see in all of those cases that I've indicated, discussed in Stubbs and Queen and matters of that nature. It's a different process. However, you still need to show that the process has been critically undermined and flawed, and that's really what it is, because we're not talking about an appeal against an erroneous decision on the merits. We're talking about something has gone seriously wrong with the procedure. That's why a real injustice in a procedural sense has occurred. And in those circumstances, 5230 should apply. And so you can have a situation, and do have situations, where 5230 can be heard by the same judge, but it's incredibly fact sensitive. As I think Lockerbale says, you know, if there's any real doubt about the sense of it, then the judge should recuse themselves. Certainly in circumstances, we say that if one party is raising issues about it, then the sensible course of conduct is to consider that, but not to be shy in refusing to do so if they genuinely believe it's wrong. But if you looked at this case and the issues that were involved in this case about the judge's decision making and process or lack thereof at the original determination of withdrawal, it was plain that he wasn't suited. The fair-minded observer looking in on that scene would say quite clearly, I don't think he's suited. And we've had the warnings not to clothe that fair-minded observer with the skills and attributes of an experienced judge. So it doesn't matter if a particular judge is capable of putting all of those matters out of mind. It's the perception. The fair-minded...
Which brings you back to recusal, doesn't it?
Yes, it does. It all comes back to...
It all comes back to recusal.
Because recusal...
Because when you say that the process has been fatally undermined, the process in question is that which led up to the first 5230 application, including Lord Justice Flaux's decision to hear it himself.
Yes, and yes, my lord, that's right. So, and the other part of the criticism, because fault has been raised, and the express request was one argument that was used against us, and the other one is your failure to respond in the interim period between the order on the 24th and the earlier date of the letter on the 21st from UCP. So there's a request issue, you weren't clear enough in your letter, and there's a failure to respond in those 2 days. And the point about that failure to respond, again we say that's an unfair criticism levelled at my client, and it certainly isn't one that supports any author of their own misfortune argument, because it comes back to the same point. How do they know that they needed to respond in the absence of any indication that that's what they should do? And you certainly couldn't criticise inaction in those circumstances within a time frame when that time frame hasn't been indicated, nor has it been said what they needed to do, if anything. So it comes back to, again, the judge is the case manager. He's the guardian of natural justice. The CPR has imposed all these obligations on the judge. Parties have to cooperate with the judge, I understand that. But the burden rests, I'm afraid, with the court to impose a proper procedure to ensure that there isn't uncertainty in this process, particularly when you are cutting somebody off from a route of appeal on an important, we say, an important case. And when one looks at the issues, I don't know to what extent, I mean, your lordships have my point, but when one looks at the issues and the reasons for accusal, we say that firstly we begin with the nature of the decision in the PTA as one of a final nature rather than simply a provisional view. And that contrasts both with the paper permission to appeal applications under the old procedure, but also with that other common argument that's raised against an application for recusal. Well, judges make adverse decisions on an interlocutory basis all the time. Well, the very benefit that is associated with continued judicial involvement in heavy cases, benefit that we obviously agree with, that benefit in those cases is the very reason why in this case, after a final determination, the judge shouldn't hear it, because it is his knowledge and experience and involvement in the relevant decision that makes it inappropriate. Whereas in the interlocutory decision...
Well, that leads to the conclusion that the same judge should never deal with a 5230 application.
Well, it's something that needs to be considered, my lord, very, very carefully. But I'm not having to say that because I don't want to... I don't want to be making a wider argument than I need to in order to succeed on this appeal. But
what you've said already is that they can only deal with this if it's something external to their previous decision, say, like new circumstances.
Yes, I mean, exactly where they don't have the potential for any professional embarrassment or have to make a decision that results in saying that they did something wrong, that they denied. In this case, the judge would have to form a view that he denied giving us a proper opportunity, however unwittingly, and based on a misunderstanding, and obviously not deliberately. But that's where he'd have to get to. And we're told that the fair-minded observer knows that judges have human frailties as much as anyone else. and therefore there's that natural human tendency to defend one's own position and to defend it vigorously. And when one looks at the hearing,
Well, it's not so much one's own position, it's one's own conduct.
one's own conduct. Yes.
I mean, you may take a view on the law, and somebody may come back and, okay, you've taken a position, but that wouldn't necessarily stop you dealing with a 5230 application. But if your personal conduct is being impugned, as happens from time to time, then you would say, well, another judge ought to deal with this.
Yes, we wouldn't allow a judge who has any form of relationship with a witness or another party, however tangential and far away, wouldn't allow it. In circumstances where, my lord, that you'd say, well, actually, this is an experienced judge. There's no chance that he's going to be influenced in any way by some long-distant cousin having some peripheral involvement or what have you. Yet we are very cautious in those circumstances. Why is it that when it becomes the decision of the actual judge, that we think that that the same factors of fair-minded observer looking in and the need to uphold public confidence should require a different decision or a different approach? It seems to me that anyone, if I went literally on that Clapham omnibus and asked, do you think it's right at this judge or should we have another one? I'm pretty confident what I'd get from the answers to them. And even if they were informed, but what, you know, and even if the judge was considered to be Dworkin's Hercules, with all those attributes of being able to find the very best decision, etc., it doesn't matter, because public confidence is what those people on the bus, as informed people on the bus, would conclude from seeing a judge preside over a review. And Stubbs and McQueen make the point that there is a distinction where one is dealing with an appeal, because in that case the judge had dealt with the second trial of a murder trial, and then it had been aborted. But during the course of that, he'd made certain decisions about no submission to hear, no submission of no case to answer, etc., and certain evidentiary decisions. There was then that trial came to an abrupt end. There was then a third trial. They were convicted, and he was sitting then on the panel of the Court of Appeal. And the point made there is, well, he made decisions that were, in his mind, final determinations. And this is not like a series of interlocutory decisions. The appeal is intended to be something that gives rise to an independent, impartial tribunal, and the appearance of that on appeal. And that having a judge that had made those decisions which featured in the issues that were before the Court of Appeal made it proper that he should recuse himself.
On the other side of the line, you've got the AMEC case, where the same adjudicator was appointed twice under a building contract to decide exactly the same point, although his first decision had been set aside.
Yes, but my lord, the submission I'm making is that when one comes to an independent review of a previous decision, then the appellant or applicant for that review is entitled to have a tribunal that has all the appearance of impartiality, and a fair-minded observer would not think a judge marking his own home was consistent with that.
I mean, is an independent review what's going on under 5230? Is it not an application to reopen, to avoid real injustice in exceptional circumstances where there's no effective alternative remedy?
But how does one do that, my lord, without reviewing? And any review must be.
But you're not. The point is, you're not. You're not deciding that the decision has to be changed. You are deciding to reopen, in most cases, by giving permission to appeal. So, I mean, if you take Mariana, where my lord and I sat, ultimately, permission to appeal had been refused. We didn't decide that the appeal should be allowed. We decided, after a lengthy hearing on 5230 that the application for permission to appeal should be reopened and that permission to appeal should be granted and that there should be a substantive hearing of the appeal, which I believe took some days.
Yeah.
Absolutely, my lord, but I mean, that is really the distinction I'm making, obviously very poorly, but when one is dealing with a 5230 application, you are reviewing the process by which the decision came to be, and ultimately you're not acting as an appellate court. That's for
I think we do need to be very clear about the distinction which my lord made earlier between granting permission to reopen and reopening. This is how I understand it at present. When you are considering whether to grant permission to reopen, which may be on the papers, but may untypically be at a hearing with the other side there, you are, in one sense, conducting a review, but not as simply a review whether you think the decision was right or not, but a review according to the criteria in 5231. So, very high bar, but
yes,
it nevertheless involves you looking at what was decided. So in that sense, it's a review. Then, when you grant permission to reopen, what that means is that at a separate stage, although conceivably it could be done at the same hearing, but completely intellectually separate stage, you reconsider with a clean slate the substantive decision. Most often a decision to refuse permission, but it can sometimes be a decision on a full appeal. Do you adopt that analysis, or have I missed something?
No, but obviously, whether one reopens, the first stage is the filter, whether this is an appropriate matter.
Yeah, but a lot is built into the permission, actually. All the 5230 case law we're familiar with is about the permission stage. Not sure it's always been completely clearly focused on, but that is what it's about, because once you have decided that there is permission to reopen, all that's left is to look at the original decision again.
I don't want to correct my
No,
lord,
well,
but I think it's not once you've decided there is permission to reopen. I think it is the question of whether you have permission to apply to reopen.
Yeah.
The first question is, so my lord, I think is right respectfully in saying there are two discrete decision-making processes. The first is, do you have permission to apply to reopen under sub-rule 4, and 5, there's no right for an oral hearing of that application, and 6, must not grant permission to apply to reopen without directing the application to be served on the other party. So what happens is the judge gets the application. He can do, or she, let's be clear about that, can do two things. First, the judge can refuse the application on paper and say, you do not have permission to apply to reopen. That's the first thing he can do. The second thing is to serve it on the basis that, on the other side, on the basis that he wants to hear what the other side say before he decides whether there is permission to apply to reopen. Normally, that's what the judge will do before deciding on paper whether there should be permission to apply to reopen. If permission to apply to reopen is given on paper, there will commonly be an oral hearing with both sides asked to attend to decide the question under 5231, should the decision be reopened on the 3 grounds I've already mentioned. And that is quite a different exercise now. In this case, I think that's right.
No, I think I mischaracterised the second stage, although I still think there's some careful thinking to be done about what exactly, whether in forensic terms, when you are conducting the second stage, i.e. applying 5231, you are in practice going to have to look at the merits of the original decision. But that will not be the actual question, that's not be the determinative question, because you could say, your application to reopen is refused, not because we think the original decision was right, but because we think you have not shown sufficient reasons to overturn it, applying the 5231 criteria. But if you decide that there will be, that the application is granted, you are almost, by definition, reversing the previous decision. Because it's hard to see how the process of reasoning that leads you to grant the application won't also lead you then to change the original decision. That's, I think, what I was blurring in my original formulation. But you're not in practice to have a third stage if you grant permission to reopen. If you allow the application to reopen, say, okay, we'll now have another hearing, which will be the reconsideration.
No.
Theoretically, you could, but in practice, you will have decided that. That's, I think, how I see it. But it is quite difficult, which is why I got it wrong first time.
No, well, it's quite difficult, but as your lordship pointed out, it's also not so clear in various cases, this two-stage process.
Well, if you take what's been called the paradigm case, and the judge reading the wrong papers, so he refuses permission to appeal, an application is made under 5230, and the right papers are put before the judge, and he says, well, now that I've read the right papers, I still refuse permission to appeal. Now, so that's really what I think my Lord Justice Underhill was talking about, that you are looking one way or another at the merits of the original, or you may have to look at the merits of the original refusal.
Yes, because, I mean, the criteria...
But formally what he will have done at that stage is he will have allowed the application to reopen because otherwise he wouldn't even be considering it afresh with the new papers. Clearly it was the right thing to do because something had gone procedurally badly wrong. But then there's a further decision, well, substantively, do I come to the same or a different conclusion?
Yes, and of course in that case there's no suggestion that judge wouldn't be appropriate to do that.
Well, that's a different point. I'm just trying to, rather laboriously and with some stumbles, work out intellectually what's happening at each stage.
But my Lord
Permission, reopening, decision on the reopened determination.
And with respect to your lordship's grappling with the analysis of that is useful because of the concerns that underpin some of the arguments that my friend raised against us about floodgates and too many applications and what have you. Because of course there is this filter that is built in to...
What are we dealing with today then? Is this an application for permission to apply to reopen, or is this an application to reopen?
Well, my lord,
You've no idea.
I don't know. No. Because
is there an order made pursuant to your application dated the 11th of November 2021?
There was a set of directions given by my lord, I believe.
And where are they?
Well, I'm now going to be exposed from having made the same error as we made.
But where are they?
I'm pretty sure I didn't grant permission. I made an order under 5235 to adjourn the application for permission to, is it 35?
What page is it?
757.
775.
757.
757. Lord Justice Underhill has directed that the application to reopen be served on the respondents and they have an opportunity to make representations, that's clear. Thereafter, the application to reopen will be listed before a constitution presided over by me.
But if I can criticise myself before somebody else does, I should have specified whether that was whether what was being done was the application for permission to reopen. I shouldn't say.
You didn't need to, because you obviously were making an order under 5236 that the judge must not grant permission without directing the application to be served on the other party and giving that opportunity. And
Yes.
then you say, so what we are dealing with is only an application for permission. So can I ask whether both sides agree that we should agree that this is a rolled up hearing in which we are determining the question of permission and, if appropriate, reopening?
Well, my lord, I came here to deal with the application notice that was served on us, and my lord.
And that's to set aside 2 of Lord Justice Flaux's orders.
Well, it's to the orders of Lord Justice Flow dated the 24th of July, which is the 5230, and the sorry,
No,
that
it's
was
the
the
second
original
PTA,
PTA,
and
and
the
the
first.
21st of January 2021. Now, it's unclear from that application notice what your lordships are actually being asked to do, whether it's just a permission to reopen or is it the reopen. Now,
No, it's not unclear. If we set aside the orders in accordance with the application, we would not only be giving permission to apply to reopen, we would be reopening.
well, that's to answer your lordship's question to me, I suppose, is are we prepared to deal with this on a consolidated basis?
Yes.
We don't have an issue with that,
No.
because the same principles are going to come into play, and the same ultimate issue is going to be one of, well, should Lord Justice Flow have recused himself, and if he didn't, what are the consequences of that? So I think we'll end up at the same
You
result.
put in a 40-page skeleton argument which explains why you think none of this should happen.
I
And
think
if
it
you're-
was 30 pages.
Oh, sorry.
Which I think is shorter than the 2 that were served on us. If that. And
Touché.
I think, to be fair to us, my lord, a lot of what that was responding to, that skeleton, seems to have been washed under the bridge.
Well, it has, because there's been new counsel. And he put in a very succinct explanation.
He has, my lord, and he's argued commendably the same points that were argued by Mr. Butler in front of Lord Justice Flow on the first hearing, which is the point your lordships have well in mind, that this is an attempt, and a very attractive attempt, to re-argue those same points.
Hang on, we're getting into your submission status. Mr. McGrath, can we just take stock of where we are? We've got very clearly on board your submission about recusal. We've had a very interesting 15 minutes on the subject of a proper analysis of 5230 and what this court is doing today. I think we've probably done enough on that. But if you want to, well, first of all, we want to know whether you've agreed a timetable with Mr. Davies.
Yes, my lord, it was an equal split. So if your lordship was sitting till 4:30, and I would stop and
Their lordships will not be sitting till 4:30. They will be sitting till 4:15.
I did wonder about that. And then I will finish. I had agreed to finish at 12:30 under the original
Okay.
proposal, so I'll agree to finish around.
So
a little bit early.
you do need to say what relevance is the legal question, the premier question, assuming obviously you're right about recusal, and if you're wrong about recusal, can you get home simply on the premier point? Do you say that?
No, my lord, we don't.
We don't say that.
I have to accept that if recusal is wrong, if you're not with me on recusal, then you're concluding that an appropriate judge looked at the 5230 application
And 5230 is final.
and it's wiped the slate clean, even though there were other you know, how one views, I think I put it at the beginning, how one would view the robust exchange between, all of that goes away because that's just bread and butter of commercial litigation.
But you're not making a Greg Middleton application. You're not saying the law changed after all this and therefore it should be reopened because it's all very unfair.
Well, no, in circumstances where the, on the assumption that the first 5230 was a full hearing before an appropriate judge, then he formed, that judge formed his own independent view as to the merits.
On the law at the time.
On the law as he understood it at the time, and properly assessed, would have properly assessed the arguments to make the procedural injustice points,
And the fact that
decided against me.
The fact that he was wrong is neither here nor there.
Well, at some point, I mean, we don't.
That comes in if you succeed in reopening the refusal of permission, then Primio comes in at that point.
Yes, but it also on the question of permission, when one looks at whether it's an appropriate application, and you're looking at a real injustice, although it's unclear as to whether that real injustice is said to be substantive or procedural, we say it's a combination of both. An erroneous decision, so therefore substantive injustice, created by and decided via a fatally flawed civil process, so that's procedural.
But delivered in circumstances of a breach of natural justice.
Yes.
So there we are.
So that's how that, and a judge
Well,
looking
that's very orthodox because all the cases say it's not enough to show that something went wrong unless you can show that there was a powerful probability that if something had gone right, a different conclusion would have been reached. You can rely on Primeo, I think,
yes.
to say, well, that box at least is ticked,
Yes.
but it's not enough on its own.
Oh, absolutely, my lord. I would have we slightly got taken off on other issues, but one of the points I would have made at the very outset is that we don't stand here saying that merits alone get us anywhere. That's not what we're saying here. We're saying it's for 5230. It's merits with the procedural injustice. It's the
I'm
real
not
injustice.
seeking any way to go behind that position, but it follows from that concession that the position is different from what it would be if, in a not dissimilar situation, if you had decided not to appeal because, let us say, Primio in the Court of the Cayman Islands, the Court of Appeal of Cayman Islands had already been decided, and you thought, well, that's what the law is, and then after the time for appealing has expired, the Privy Council reverses the Court of Appeal of the Cayman Islands, and you might then come to court and say, can I have an extension of time for appealing? My reason is it was a sensible decision not to appeal at the time, but now the law has changed. And the Greg Middleton line authorities, to which you were alerted overnight, says no absolute rule. In certain circumstances, saying the law has changed in the mean it's changed since maybe a sufficient ground for giving belated appeal. It all depends, and multifactorial test and so forth. But you are not saying that here, presumably because 5230 is a very particular beast, and the importance of finality is particularly great in 5230, more so than it is in the kind of situation I just put to you. Is that where was that?
My lord, yes.
Yes.
What was also interesting from the Middleton case was that although they're only dealing with the principal question of merits and the subsequent decision, that the court took the line of needing to show special circumstances and looking at the case in the round, whether the litigation and dispute between the parties is ongoing, whether the books have really been closed and everyone's moved on, sort of considerations which in many ways are wrapped up in the exceptional circumstances and real injustice in any event of 5230. You know, can you show that you've been caused a real injustice by what's gone on, and can you show that that happened in exceptional circumstances? So it's interesting, but of course, in the Middleton case, you're talking about authorities where there was the time bar had expired and been allowed to expire. And I think there were some of them came from the automatic strikeout cases, which, if I remember correctly, in the early part of CPR was if you did nothing for 12 months, you'd have a strike that your case would be struck out. So when Lord Wolfe said 10 months was just about okay in one case in there, it was an automatic strikeout, so nothing had been done for a year. Then the 28 days or what have you for the time period to expire, for the time period for appeal had expired, been allowed to expire. And then there was 10 months added on that. And he said that that was okay as a period of time. Not okay, he said that that was probably the outer limits. But that's a hell of a long time to be doing nothing on your case. And it certainly doesn't resemble what's gone on in this case.
No, I'm not really wanting to get into the facts of that case or the whole series of cases which are reviewed in it, which, as you say, are of a variety of different kinds. But I'm just trying to pin down, for my own clarity of thought, why you accept that a different approach is required in the 5230 type of case. And I think you've accepted it because 5230 is a very special kind of animal.
It is, and it's the cases that deal with it emphasise its special nature, and indeed rather suggest a somewhat annoyance that the exceptional nature of this process hasn't properly been taken on board by litigants. So we recognise that, and it isn't just simply to say we'd like a different decision. It is that we need to prove that the way the decision was reached gave rise to serious breaches of natural justice, and for the reasons that we've explored already, that is our case, and that's what we say. And of course, we have we've talked about the 3.35 application. In those events in the immediate aftermath, we also have the second event, which was the order and the 5230 time limit. And I would just say that on the basis of what the judge says, that any application he understood to be inclusive of 5230, that would mean we were being told on the 30th of July.
So where's the time limit imposed?
It's imposed on the 30th of July for 7 days. On the 28th of July...
What's the page number?
Page 96.
Right, yes. So what did he mean? What's the context of that?
Well, my lord, if you turn back to 93,
Yeah.
you have my instructing solicitor's letter. So this is immediately in response to the 24th of July order on the Friday. This is the following Tuesday. And the solicitor's right. Now, there was a 7-day period in order to bring, CPR imposed a 7-day period to bring the 3.35 application. But there's no period in which to bring the 5230 application. So my instructing solicitors are writing to the judge to say, or to the court to say, can we have an extension to the 3.35 application so that we can bring it at the same time with an alternative on the 5230 in September, the other side of the summer. Because obviously with the no alternative remedy criteria, if we did have a remedy under 3.35, then we would be shut out from 5230. And So they ask for an extension of time. So the only thing they need is an extension of time for 3.35. The reference to 5230 is the context. They would wish to bring an alternative. But that obviously would require proper preparation and careful consideration, and they asked therefore for a date in September. And then there's a response on page 95 from my friends at Strickland Solicitors opposing that. And then you have the direction from the judge on page 96, just simply saying any application. And then, my lord, just to complete it.
So that included 5230.
That's what the judge said in the hearing.
I'm sorry, my lord,
That included 5230. He'd given you a time limit for 5230, even though you only asked for a time extension of your time limit for 335.
we only asked,
Yes.
and he says at the hearing that he imposed a deadline on both, whereas that was not the way it was understood at our end, because the only application that required a deadline extension was 3.35.
Yeah.
5230.
Okay. Got all that.
So this goes to what? Because he did hear the 5230 application, even though you didn't comply with
Yes.
what is said to be the deadline.
The point this goes to, my lord, is that in the context of the arguments on delay, and you haven't moved quickly enough, it is said against us that this order imposed an obligation to issue the 5230 on the 1st of July. You didn't do that. You allowed that to expire, and you just did it whenever you felt.
But does this go to recusal? So I understood, in answer to my Lord Justice Underhill, that really what it all boils down to is that Lord Justice Flaux should not have heard the original 5230 application.
It does both, my lord. What it does in respect of recusal is that a fair-minded observer looking in on this is seeing that an application that is not subjected by the CPR to a 7-day time limit has now been imposed with a 24-hour time limit, being informed on the 30th to do it by the 31st. Now, when one looks at the nature of this application and the concerns expressed in the case law as to the need to treat it exceptional and that allegations, etc., shouldn't lie down, we say it was plainly inappropriate to impose a 24-hour deadline on guillotine if that's what he intended to do.
So that's a fourth complaint of apparent bias.
My lord, yes. And
Are there any more while I'm...
no, my lord. But just to finish the run, on the 3rd of August, we had the Court of Appeal in page 128 in the same part of the bundle. The 3rd of August, where we have the refusal to issue.
Yes.
And then we have details about the only route available to you, Lord Justice Flaux has told us, etc., is 5230. Well, there's no mention in this letter that you're already past the boat on that the boat sailed because the time period expired, or etc. There's no mention of that. And I put that in because, you know, our understanding of the position was that the time period applied only to the 3.35, and that there was nothing in this response given at the direction of the court, and had the judge only a matter of a few days before intended his order to apply to 5230 as well as 3.35, what one would expect it to have been, and you're out of time on that.
But to be fair to the judge, he doesn't decide the case on the delay point at all. He says simply that it would be a factor weighing heavily against allowing the application, even if it otherwise had any merit. But that's short of saying I would have decided on that basis anyway. And in the rest of the paragraph where he's criticising the delay, he is clearly not saying you were out of time on the 31st of July. He's really criticising how long it took you between the email of the 3rd of August, when you were told that in his view it was 52.30 or nothing, it then took you another 2 months, only because it was the long vacation. He didn't think much of that.
No, he didn't, my lord.
I can see why.
But of course it is the reality is, well, the evidence as to that and the passage of time and people being away is set out. The application was made on the 28th of September. So, I mean, that's before the new term.
Yeah.
is official.
Well, I suppose the only point I was really making was that it's not held against you, actually, that as such, that you should have treated the 31st of July as the time limit for making a 52.30 application. There's perhaps a hint of that, but it is not actually what he says or how he decides it.
No, it's not how he decides it, and I mean, that's really as far as I need to take it. It just explains the context of the arguments on delay, that insofar as it informed or influenced his views on delay.
And it's not a point that was taken, was it, in the original skeleton argument, applying for permission to apply to reopen? I'm looking at the skeleton at 165, I think it is. No, 162 to 176, and it's not. That's the 31st July point is not one that's taken. As far as I can see.
Well, of course, there was as you've seen, there was no mention of the 31st of July deadline applying to 52.30 and the 3rd of August email from the Court of Appeal. And as I understand the position, it wasn't mentioned at any time in the run-up to the issuing of that skeleton. So,
no, indeed, but the point is that you weren't complaining about it as a reason why Lord Justice Flaux should have recused himself.
no, that's right, because it hadn't been made known to us that it did apply, or that he understood it to apply. That's the way I would put it on. And then it came up actually at the hearing.
Which you did have in big italics at the top of your skeleton. This should be heard by somebody other than Flaux LJ.
I'm sorry, but I missed the
You
beginning.
did have at the
Yes.
top of your skeleton. Can we please have another judge?
And that was cross-referenced from box 8 on the application.
Yes, and 22 to 24, but never dealt with. It's strange that counsel didn't raise it at the hearing. Have we got a transcript of the hearing?
We do have a transcript.
It
It wasn't raised. I think the explanation is that the court had made its position very clear, and as far as frankly, my lord, there is a forensic
antagonising the judge who's going to decide your case anyway.
Well, there is that. If you're sitting in front of me and I'm saying you shouldn't be here, and you've already told me 3 times I'm going to be here, then frankly, I'm not starting off on my best point.
That is overstating the case.
No,
You had been told that the judge would decide for himself whether he ought to recuse himself,
yes,
and it was clear that he had decided not to, or almost certainly that's possibly just not picked up the point. But surely, although of course you could do it at the start of the hearing, and that would be very tactless and distract from the hearing, though it might have to be done sometimes, you have plenty of opportunity to do so in the interval between being told this is going to be listed in front of Lord Justice Flaux and he has made the following directions, which was in early November, and the actual hearing of the case in January. That's at that point, all that embarrassment about saying to the judge who's going to hear your case, he shouldn't be, wouldn't have arisen, or at any rate wouldn't have arisen so acutely.
My lords, I think I made it clear at the outset that it's set against us that you could have made a formal application, issued an application notice for recusal, or you could have repeated the points at the beginning of of the hearing. Neither happened, but my answer to it is that the absence of that formality cannot disguise the force of which points were made as to the inappropriate nature of this particular judge sitting on this particular hearing and dealing with this hearing, including on the skeletons.
Right, where do we go from there?
My Lord, you will have seen in my previous council's supplemental skeleton the extracts in respect of the handling of the hearing itself. And I think I used the expression like a dog with a bone on the question of express request. And your Lordship's seen that. I don't think I need to take you through all of that. What I don't say, my Lord, is I don't say that it was not possible for our submissions to be made, because I'm well aware that the judge had the benefit of written skeleton, and therefore I will have read that and the papers. But to a fair-minded observer looking in, or an objective judicial assessment of what's going on, it's abundantly clear that the judge is adopting a position, or appears to be adopting a position is more accurate, but I hope when I stumble and don't say here before every sentence, it's quite clear that's what I intend. Appears to be adopting a position in which he's more focused on the defence of the his own conduct and the conclusions he reached, more than fairly listening to the arguments against. There's constant interruptions, and I think I said in my note that robust exchanges between the court and council are the bread and butter, and long may that remain, however uncomfortable it might be for some of us when it happens. But that's part of the process. No problem with that. But a fair-minded observer sitting in and watching from the back, in a circumstance where that robust exchange is about something that the judge did or didn't do, or understood or didn't understand, it starts to look like the judge is being an advocate.
So
in his own cause.
can I just be clear about this? If you're wrong about recusal, so it was perfectly appropriate for Lord Justice Flaux to hear the first 5230 application, are you saying that his conduct of that hearing is of itself enough to set aside the 5230 decision? No.
No, I think I said twice, and I make absolutely
Well,
clear.
are you saying it, so to speak, is retrospective evidence of why he should have recused himself?
Yeah, yes, because of course he shouldn't have been there in the first place, if I'm right. But the reason why he should have recused himself became evident in the manner of the exchanges. But that if your lordships were against me on recusal, and he was entirely appropriate to listen, then the robust exchanges would fall within the normal bread and butter, because no one would be viewing them from the outside as involving anything other than a judge being investigative about certain issues.
And a judge who had taken a firm view, but not out of nowhere, a firm view on the papers beforehand, and was pressing counsel with it.
Well, I mean, it's useful. There's nothing more unhelpful than a judge sits there and saying nothing and then finds against you. You know, we all think we've done our bit.
No fear of that here, Mr. McGrath.
No, that's absolutely right, my lord. And more of that would be good, frankly, because we all know where we then stand. There's no point me addressing points that of no interest to you. And if you don't like them, I want to know why you don't like them. So, to be absolutely clear, if you're against me on recusal, these other points about the handling that are set out in the supplemental skeleton are not in themselves independent grounds.
I mean, this case turns on recusal.
It does. Everything is on why this judge should not have heard this case. In order for me, not when I say everything, we've got to be careful. Obviously, there's the initial real injustice at the beginning, which is the driving force of all of this. But I won't get there if your lordships form the view that there's been a wipe slate of the claim by the first 5230 application, and we're in an unusual situation. We say, well, that judge shouldn't have heard it, and so that process hasn't wiped the slate clean.
Yeah, well, if he shouldn't have heard it, then he hasn't wiped the slate.
Exactly.
If, on the other hand, he was right to hear it, or at least entitled to hear it, then a lot of the slate has been wiped clean.
Absolutely, and with it goes the concerns about the never-ending 5230s, because, I'm being accused of, not accused, it's being called the renewed application. Well, if I'm right, we never had a proper one in the first place. That's really the point.
Well, that's really what it comes to, and you're putting the case on a very much narrower basis than appeared to be from the first two skeleton arguments.
My lord, yes, and I hope that the note, made that clear, albeit in a very succinct way, without trying to sort of produce yet another skeleton argument for your lordships to read. So it does turn on the recusal, and I think I've addressed your lordships as to why I think, why I submit that he should have recused himself from this hearing, and I just want to make sure that I've covered all the points. I accept, my lord, the one that hadn't been previously raised, which your lordship indicated that he hadn't picked up, and he hadn't picked it up because I hadn't previously raised it, and that was the significance of the 335. But we had raised it as being denying us a route to answer the original problem that was easier route than the 5230. But looking at the wording, it plainly raises an issue of an added factor of closed mind, because you would have made up a conclusion that there had been a proper opportunity.
And just for clarity, and this is a fault of my note-taking, you were making a point, and my lord the Master of the Rolls said, well, that's a fourth complaint of apparent bias, and I hadn't picked up what that was. Was that this point, or was that another?
No, the fourth was the 52.
Imposing the
30
time
limit.
Imposing 24-hour time.
Yes, I see.
Yes.
Yep.
The 4 points were the denial of the issue of the 335, deciding the Marex point, having decided the Marex point already, but that's a peripheral question, but it probably should be number 4. Refusal to have submissions on the second PTA, and making a decision on the letter in the way that we know he did, and the last is time limit, imposing the time limit.
Would your lordships, because we were taken somewhat out of term, but the letters, I appreciate that your lordships will have read them with care, obviously, and you will have picked up the two instances where the howevers and the alternatives arise in the context of our letter. I just want to make sure that that's in. If I could ask you to turn to our letter, which is page 87, tab 3.
Annoyingly, I took it out for another purpose, but I can remember it.
Right, thank you. And one could see that there's firstly, the first point to make is it's 2 pages. It's 2 days after the decision's been handed down, it's 2 pages. It's clearly not any detailed reasoning of anything at all. And I take the point at the last paragraph on that page, where there's reference to an appeal skeleton, is they're referring to the substantive appeal skeleton on the basis that permission has now been granted without any contingency. And the whole thrust of this letter is, given Marex, we move to contingency. That's what we invite you to do. No suggestion of any other approach. And then on the next page, page 88, the third paragraph says, in Nectrus's submission, it therefore remains strongly arguable that the judge erred in not concluding that UCP was precluded from recovery by the reflective loss principle. However, if the court would like to receive further submissions on this topic from the appellant or both parties, the appellant remains at the court's disposal and would be pleased to provide a replacement skeleton argument in support of its application for permission to appeal. So we say, and let's not kid ourselves about it. The language could have been clearer on this point. But we say it's quite obvious that we're saying to the court here that Marex plainly points in one direction in our favour. But, however, and then it's unfortunately expressed if the court would like. And of course, the judge says, well, I wouldn't like. And that's where that Norman Berg thing
You mean
came
it should have said, but if you don't agree that it's obvious, then let us explain why.
Yeah, I mean, it could have said that. This is all on the basis that there's actually any merit in the argument that we should have been clearer. Because my primary submission is that we wouldn't be into this discussion if this letter had been part of an agreed process. Because then they would be putting in the submissions that they were told to put in by a certain date, and would know then that they have to put in more if the judge wasn't going to be against them. And then the second to last paragraph on the same page, same sort of point. In view of the foregoing matters, Nectrus invites the Court of Appeal to remove the contingent basis of its grant of permission to appeal and direct that the appeal be stayed pending, etc. In the alternative, so if you're not minded to do that, if the Court of Appeal would like further submissions, again, I mean,
It's the if.
if you would like, and then you say, well, I don't like, and I suspect 9 times out of 10 your lordships are always grateful not to receive more documents and more submissions, and which was the response that the judge gave. But look at Lord Bingham's analysis of the young Berker. Would your lordship like to hear from me? No. And then he decides against him, and he says, you told me you didn't want to hear from me. And he says, well, I didn't, and I still don't. And that's put down as, you know, come on, that's not the kind of behaviour that we'd put up with. And
We don't do that these days.
We don't do that. No, it's not. But equally, you know, polite letters. It's quite clear from this letter alone that Nectrus is adopting a position that there's only one route, but if you're against us, there's further submissions. There's further things to be said if you're not with us.
I don't think, Mr. McGrath, the point can be elaborated. You say should have given proper time for proper submissions and didn't.
And if I would just make this point, then, Lord, that if you didn't get that from our letter, then when my friend writes his letter and asks for, quote, the converse, namely, he says, reject the permission, or on paper alone, or will put in submissions, he refers expressly to the procedure in the PTA and the entitlement to put in a free-pager. So they're suggesting that if this isn't going to be decided in their favour on this paper, what they wanted is for us to put in our amended skeleton and for them to put in an equivalent free-pager in response if the court was against them. Now, the court's then faced with two diametrically opposed views on the meaning of the Supreme Court decision. It doesn't take rocket science to know that it should say, you guys are passing like ships in the night, these two letters. I want you to address the points that arise. Where do you say in Marex is supportive of what you're now saying? But that never happened. Lord, on the question of author of own misfortune, can I deal with it very, very simply, and that is that the arguments which we've just been looking about, the letter could be clearer, and you could have done something in the interim period. They're really, those criticisms are the flip side of my arguments that we shouldn't have been in the position that we had to do those things to make the system work. There should have been a clear timetable. If that had been done, then you wouldn't be asking for us to request more time because the time would be set out. And if we wanted more time, we would know we would need to request it. But that wasn't something we knew. As regards the 2-day window, again, if that 2-day window is to have any bearing on our conduct, it should have been set out that in fact he was treating the exchange of letters as the final word, the only word that anyone needed to have said on Marex, and therefore you should get in a response if that's what you wanted to get in. But we say they're unfair criticisms of my client because and to some extent the matters a confirmation bias, which is the other consideration here, because the judge is hanging on to them as justifications for his decision. You may genuinely believe them to be true, but to the outside world, they will look like points that are being hung on to justify why no why the decision and process was as was. And we say no, that disguises the fact that all this is taking place in a fundamentally flawed process, absent any question of timetable. And then on delay, my lord, you will have seen the evidence and the submissions. The first CPR 5230 was lodged on the 28th of September. It wasn't determinative, as your lordship said, any question of delay as far as the judge was concerned. The second CPR 52, this one was lodged in November. Judgment was January, and Primio came out in early August, but became known to my instructing solicitors in early October, and within that month, notwithstanding 2 medical procedures, the application was issued. It'll be said against me, well, Primio, you should have been alert to it, you should have been alive to it, etc. And we say, well, you know, some will have known about it more than others. A judgment that comes out in the summer, however hard and diligent, some might be still working, others, if they're lucky, are away, and things can go under the radar. It's also not necessarily something you're necessarily looking for, and it's something that you just have to become aware of.
I forget whether the evidence is that it was generally known that the decision of the Court of Appeal of the Cayman Islands or East Caribbean, whatever it was, had been subject of an appeal and had been heard.
I don't know. I believe there's some.
My lord, I was certainly aware of that fact.
Oh, well, I'm sure.
But-
I'm not asking about individuals. I'm just.
But whether it was reported in the press, I cannot tell you.
My lord, the evidence from our side as to when we became aware comes from Mr. Ammon, and he became aware of it on the 4th of October. We got instructions to apply.
I don't know. I'm not sure this is the case in the Town Office, but I don't know whether the Privy Council publishes its, as it were, permission to appeal decisions if permission is required from that particular court.
Well, it's a funny position from the Cayman Islands.
Yes.
I used to sit in that court.
I know.
But you ought always to know, if you're interested in these things, and it's easy to find out whether permission has been granted in, not always whether it's been applied for, but whether it's been granted in the Supreme Court. But I don't know whether the same is true in the Privy Council. But I'm probably wasting time at this point.
It involves the details of keeping an eye on things and being aware that there are things to be kept an eye on, and that things have happened in the middle of August, which, you know, that might, if they'd happened in the middle of October, come to someone's attention far quicker. And obviously, without the support of Primio, there was a danger that, you know, you were never going to get the court interested in another 5230 application on the, however meritorious the other points, because it was, well, this is the view, this is what Marex decided. But Primio is very clear that its understanding of it. As regards the, I'm looking at it, I appreciate that. The last point I would say on this, then, my lord, is this: that it's said that the law in this area is clarified, and that therefore you don't need to worry about the second aspect of the Taylor-Lawrence criteria, the public objective, which underpins 5230, which is clarification of the law as well as private objective about doing right between the parties. But the law is still somewhat uncertain, because the decision of His Honour Judge Paul Matthews in the Burnford case said that he said that the decision of the judge was binding on him, and that he was, unless he could distinguish it, he'd have to follow it, notwithstanding the Privy Council, because there was no Willers and Joyce statement in the Privy Council. Now,
what authority is there for the proposition that a decision of a single Lord Justice binds lower courts?
I put it forward not that he's necessarily correct, but that there's still uncertainty within certain elements anyway of the judiciary that as to whether or not they can follow Privy Council or instead of the decision of the judge here. Now, he could be right or wrong about that, but that uncertainty still exists, and you have a unique opportunity.
Sorry, I'm not really caught up with Burnford. What did Matthews say, Judge Matthews say?
I think he referred to a statement made by Sir Nigel Tier, who got it from Lord Justice Flaux,
Yes.
that even though it was a refusal of permission application, it was intended to be citable.
Yes.
Being
Well,
citable is not the same as being authoritative.
But that still begs the question, what is the precedential value of a decision by a single Lord Justice? And see, it's persuasive for lower courts, but what says it's binding on lower courts?
Well, my lord, I can't answer that question, but what I can say is that the purpose of my referring to Burnford is to simply say that whether he's right or wrong, it's an example of a recent case which believes that the tension between the Premier and Nectrus on this issue.
That's soluble. If we were to refuse your application, that problem is soluble if we say that it's the Lord Justice Flaux's decision is not binding.
Oh,
on lower
absolutely.
courts.
But well, you could, yes, you can. You can
So you don't need the permission in order to make that point clear.
No, that's a fair point, my lord. I just simply say that one of the reasons why 5230 would be engaged on the Taylor and Lawrence is that. So if you were going to do it, it would be an extra reason why you should do it. My lord,
I point whether a statement by us that it was not binding was trumped a decision, trumped Lord Justice Flaux's statement that it was binding. If the whole problem is that it's made in a 5230 context. But anyway, perhaps that wouldn't be a problem.
But unless I can assist you, Lord, unless I can assist you any further, I'll let my friend.
Anything else?
No.
Anything else? Anything else? Kim? No. Okay. Thank you very much, Mr. McGrath. Mrs. Davies.
My lords, I think listening to the debate with Mr. McGrath, it's quite clear, or we all seem to be quite clear, the nature of the application we are dealing with today is under 5230. I start by saying that because we were obviously made aware of the reference to the Craig and Middleton case as well last night. My learned friends passed it on to us. And this is not an application for an extension of time by my learned friends, and they're not seeking to rely upon the jurisdiction that might or might not be provided by the Greg Middleton case.
The Greg Middleton point was not put forward as an alternative issue as such in the case. They are obviously quite different. But it's because it might have been said, it turns out it isn't, that the fact that there has been a subsequent decision from Primio is itself enough to engage 5230, and that in such a case it's all right to trump finality. And in that case, Greg Middleton might have provided a useful analogy, but he's not putting it that way.
My lord, and that is helpful, because I was going to start with, I know that in our skeleton, just for your note, paragraphs 40 to 56, we set out various principles that we say apply to 5230 applications. Now,
Which paragraphs?
paragraphs 40 to 56, which is pages 453 to 456 of the bundle. Tab 9, 453 to 456.
Sorry, I'm taking the skeletons out. Which paragraphs?
It is paragraphs 40 to 56, Michael.
Yeah.
And I think we've there set out 10 principles that we seek to rely upon as that one can discern, certainly from the authorities. And one of those points that we do rely upon is the fact that permission to appeal might have been wrong is not of itself a reason justifying reopening that permission to appeal.
Well, maybe not that it might have been wrong, but it is a second fact. Once you've determined that the procedure's gone wrong, then you have to show there's a real chance that you're actually going to succeed on the appeal. A different result will follow.
My lord, your lordship is quite right. It has to be shown a powerful probability that the decision would have been the other way. But your lordship is quite right that the first thing you are doing is to see whether or not the procedure has been critically undermined in the first place. And if you don't get through that hurdle, then you don't get to the second hurdle. And that's important, we say, in relation to this, and because the way in which the argument has gone on, it maybe there's no difference between us now, that it's critical, we say, that my learned friend succeeds on his recusal argument.
I think he accepts that.
Which he has now accepted. Now, and I was very grateful to receive my learned friend's 4-page note, which was succinct and let me know what the case was that I was addressing. But that was not entirely clear from that note as far as I read it. But, and there are, we would say, 3 levels to this recusal point. Firstly, are they even entitled to take that point at this stage? Having failed to take it, we say in front of Lord Justice Flaux, the Chancellor, as he now is. Secondly, was Lord Justice Flaux wrong not to recuse himself on the facts of the case? And thirdly, if he should have recused himself, if your lordship say, well, yes, he should have recused himself, then it's necessary for your lordships to consider whether or not, by failing to recuse himself, there has actually been a critical undermining of the process, i.e., was the actual process that was put in place critically undermining the justice system, essentially? Was there a breach of natural justice? Now, on the, skipping through all the issues on the scope of 5230, if I may, but just to go to the issue, legal principles on recusal and apparent bias, because the whole basis of the recusal allegation is that there was apparent bias on the part of Justice Flaux. Without that, there is no basis for recusal. So these two topics go together. But the first point I want to deal with is if a party wishes to contend that a judge should recuse him or herself, it's incumbent on that party to issue a recusal application as soon as practicable. And if I can I show your lordships the Baker and Quantum Clothing case, which you can find at tab 14 of the authorities bundle. And if we go to paragraphs 35 to 36, and for my lord, that is page 528 in the authorities bundle.
Sorry, which tab is it? 13?
It's tab 14.
14. This is the Lord Justice Jacob point, isn't it?
It is, my lord, yes. And Lord Justice Smith. So it's Lord Justice Jacob with whom...
Lady Justice Smith.
I beg your pardon, yes. Where you'll see at 35, the delay, this is an application for the recusal was made, and it says, Lord Justice Sedley said out at the outset that if you think of something, make sure I know fairly soon. In those circumstances, it's particularly surprising that Whiteman say they only discovered certain of the matters relied upon 2 weeks after the hearing. We have unchallenged evidence from Mr. Fry of Wake and Smith leading to the clear inference that Bayard of Wakeman's had visited the BTA website during the hearing, even accepting that the matters concerned were only found 2 weeks later. There is no explanation of why they were not found earlier. Further, it's astonishing that having found the material, the applicants took no action for a further 5 weeks. We draw the inference from this delay, and the matters now relied on were not, at the time of discovery, seen as serious. Now, Lord, just pausing there, that's pertinent in this instance, where you have a hearing in front of Lord Justice Flow, and I'm going to come back to whether or not there should have been an application for him to recuse himself before the hearing, but after they've had the decision, they wait 10 months before they make this application.
So they wait 10 months after what?
After Lord Justice Flow's decision in this case.
Oh yes. Well, they probably wouldn't have applied if it went for Premier.
January 21, and well, I'll come to that in just a moment. But it's then in November that they finally issue this application. Now, if they had any semblance of faith in their argument that Lord Justice Flow was guilty of apparent bias and he should have recused himself, that should have been made immediately, if not before, we say.
Well, I mean, just the point is the point I made, isn't it? I mean, you have to show two things to make a 52-30, let alone to make a second 52-30. and the second of them is you've got a really good chance of winning. And they obviously accepted that this Lord Justice Flow had been entitled on the substance of the case to decide that Primeo CICA was an authority against them. So doesn't that justify the inability to set the hair running until Primeo is overturned?
Well, two arguments to that. Firstly, I'm not sure I would necessarily accept that, because if they do overturn the first ruling, that part of their argument has been, until Mr. McGrath's submission today, well, he should never have made the ruling he did on the Marex point in my favour at the permission to appeal stage. So they would have had another bite at that. But the most important element is the criticism of Lord Justice Flow and the integrity of the process. Now, I take your Lordship's point. Premier comes out in August, so effectively my learned friend says, oh, well, I was entitled to wait and see.
Well, it's an expensive hair to set running.
It is, my Lord.
If you don't think you've got the final coup de grace in the form of a Privy Council decision, which must have come from manna from heaven, even if they didn't even read it for 2 months.
Well, and I am going to say that on this side of the court, we were aware of that decision as soon as it came out. And
you're giving evidence.
I am, my Lord, but it was an important issue in this case throughout the years that we've been running. And it's an important decision generally in the law. And I'm afraid, with all due respect, I don't accept this notion that it can go unnoticed, even if it is produced in August. And then therefore to be...
How long did it go unnoticed for, exactly?
Pardon, my Lord?
How long did it go unnoticed for, precisely?
Well, it came out on the 9th of August, and I'm told that it was unnoted by my learned friend's solicitors, which is the evidence. I don't know about counsel, until October, early October, 4th of October.
And when did they do something on the 4th of October?
And then nothing was done until November.
No, instructions were received on the 14th of October.
Sorry, I misheard that.
I hear 14th of October is when instructions were received from clients.
But the date of this application is early November, isn't it?
It's November
3rd,
11th of November.
11th. I mean, I get all that, and I don't want to underplay it. But if the process were undermined by serious injustice, it might be hard to say that their delay had overborne that injustice. I mean, the delay over the summer. I mean, we do take judicial notice of the fact that the 9th of August falls in the long vacation.
My Lord, yes. Okay, well, my Lord, I see that point. That is post Lord Justice Flaux's decision. But if I could take you back to the next paragraph in the Baker case that I was showing you, Lordship, where it is stated at paragraph 36, finally we think this objection simply comes too late. It is not open to a party which thinks it has grounds for asking for recusal to take a leisurely approach to raising the objection. Applications for recusal go to the heart of administration of justice and must be raised as soon as practicable.
But that was that case, wasn't it?
Well, it is, my Lord, but that is... But it is critical that if you know you have grounds for recusal, that you make your application, and our case is that there should be an application for recusal, a formal application. You can't just put in a request that another, we think it's appropriate that another Lord Justice or Lady Justice deals with this matter.
That's a different point.
That's a request, my Lord. That's not an application that Lord Justice Flaux be recusing himself.
But paragraphs 24 to 26 do actually say he should recuse himself. I mean, I am puzzled by this case because if I had been the judge, speaking only for myself, and I'd seen paragraphs 24 to 26, I'd have been onto the court office in seconds and said, well, there's an application to recuse, it's got to be heard separately, or I've got to recuse. So I'm slightly puzzled that...
Well, my Lord, well, maybe we'll look at 24 and 26 in a moment, because that, with respect, I don't read that as an application for recusal. It is a request that is made essentially, as I think your Lordships are already aware, there's a ticking of the box in the application notice saying appropriate for another, for a lady.
But I mean, what I'm puzzled about is I'm sort of, there seems to be a missing step to me, and the missing step seems to me the likely to be that the judge looked at it, it was drawn to his attention when the skeleton was filed or shortly before the hearing, and was said, will you recuse yourself or will you go ahead? And he said, I'd go ahead, and that communication was made to the parties. I mean, I don't, they're shaking their heads, so that probably didn't happen.
I'm not sure that is quite how, can I come to the facts in a moment? I just want to finish running through the principles, if I may.
Sure.
And to show you what Lockerbie says
Yes.
on this point. Because what the party is not allowed to do is to decide against pursuing an application for recusal.
Are you creating? Do you want us to look at Lockerbie?
I am going to go to Lockerbie now, my Lord, yes. Okay, well, if we
I
go...
just thought you were quoting from it, and I was
no, I wasn't. I was just making
right.
some
Keep going.
comments. In the knowledge that the basis for making that application, he then takes part in the hearing, hoping, well, maybe it'll go my way, but if it doesn't, what I'll do is make an application based upon apparent bias, which I should have made before. That's exactly what has happened here. There was a conscious decision not to make an application for recusal to his lordship, and they took it, they winged it, basically. They wanted to have the bite of two bites of the same cherry.
Well, if that's really true, is a serious point.
Yes.
Because I mean, we all are familiar with cases where the judge comes in and says, Mr. Davies, I've looked at these papers. Mr. Smith, who is mentioned on page 473 of the bundle, is my fourth cousin, 5 times removed. I last saw him 20 years ago, and I would probably not recognize him in the street, but I wanted to declare that as an interest. And counsel all dutifully turn to their solicitors and say, that's fine, my lord. And having done that, you can't complain afterwards that the relationship with Mr. Smith was a problem, unless, of course, you were told false information about the relationship with Mr. Smith. Now, that we're very familiar with. What you're saying is that they actually took a conscious decision not to make an application and not to raise it with the judge. And what I've been putting to you is that another possible explanation, because we haven't got evidence on this, is that they had been told expressly or impliedly that the judge had decided against them. Now that's really a question we need an answer to.
Well, I think we need to look at the correspondence between the court and my learned friend's solicitor.
Is there a simple answer to the question?
Well, we say there is, my lord.
Which is what?
Well, that they... Well,
he said that it could be inferred from the correspondence. That it wouldn't be
it's important. We would say you cannot infer, and this is the problem of them not making an application. We don't know all of those facts because they did not make an application to Lord Justice Flaux, which would have entitled us to respond to that application, which we never did or had the opportunity to.
Did you not say anything in your skeleton?
My lord, we didn't need to, because they didn't pursue. If they'd pursued an application, we would have done.
Well, maybe, but on the face of the skeleton, the point was still live. Obviously, you didn't have to put in a skeleton, if I've got the timings right, until after a decision had been made that it was going to be listed in front of Lord Justice Flaux.
Yes.
That's right.
I think that's right,
Yeah.
Mr. Davis.
That's quite
because
right.
the timings is your skeleton is at the very beginning of the whole thing, because it's in support of the application. Sorry, their skeleton.
Yeah.
It's in support of the application made.
Yeah.
They quite clearly do say it should be listed in front of someone other than Lord Justice Flaux. Then they're told it's going to be listed, or there's some correspondence. And at that point, they say, "Can we just remind you that, of course, we say it should be listed in front of someone other than Lord Justice Flaux." Then they get the standard letter back. Then they say what they say in that letter about respectful evidence is made. They don't at that point know it is going to be listed in front of Mr. Justice Flaux. Then a few weeks later, it is as a letter saying Lord Justice Flaux has directed that the case be heard in front of him, and gives various directions. And only at that point do you, and I think he then makes directions for a skeleton, which you then do.
Yes.
It might be thought, therefore, that the reason you don't deal with the point of the skeleton is that you too take the view, well, they may have objected, but Flaux's directed to be in front of him, so end of story.
Well, and there is no application, my lord. That's
Well, there was an application at the very start. Depends what you mean by an application. There was an application on Part 23.
Well,
But there was an application, I think, ticked in the opponent's notice, the application notice.
Would you mind taking us through what my lord just described from his recollection on the papers?
My lord, yes.
Because I think it's really important.
It is, and that is something I was certainly going to do.
Well, it's 12:58. Can we do it in 2 minutes?
Might be a slight struggle, my lord. But,
Well, if you give me the page numbers, I'll read it over in German. I don't know why this bundle, because these documents are not in a chronological bundle, but in exhibits to the statements. It makes them very difficult to find unless you know the date you're looking for. I don't on this occasion.
well, my lord, the I'll give you the page references here. We've got their skeleton, which your lordship probably.
Well, don't you need to start with the applicant?
You do with the application
Yes,
notice.
right.
My lord, it's probably going to take. I'd like to actually take your lordships through it, if I may.
Okay, we'll
It'll
look
take
at
me more
it.
than a minute.
We'll look at it at 2 o'clock, Mr. Davies. We're not in time trouble to finish at
I
4:15.
don't think so, my lord. No.
No, I mean the case has actually narrowed quite
It
a lot.
has. Yeah.
Okay, well, we're very grateful. We'll see you at 2 o'clock.
4 5.